All right. All right, we're back on the record on State versus Loyd. He's present in the courtroom along with his attorneys. State Attorney's Office is present. You all will be prepared to move this trial tomorrow morning. We're going to a felony courtroom. I've had it with the elevator on this floor. So I'll give you the courtroom as soon as I know. Freaking hell. All right, let's wait for a minute to get that juror up. Our plans to start early, of course, have failed miserably. Is Derek out of that elevator? Do we know? Or is he still stuck? Is he out?
Yeah, he's out.
Do we have the 11 jurors that were asked to come at 1 o'clock? Do we know? I thought we had some that were coming at 1, yeah. Because I feel bad because we asked them to come at 1 and then haven't called them in here. So, Jesus. All right, I'll explain it to them when they get in. Thanks. Yes, ma'am.
You're ready. Jurors are ready. All right now, watch your step, all right now. I got it. Ladies and gentlemen, would you please raise your right hand, face the clerk of you sworn and answer my question.
Swear to be solemnly swear or affirm that you will answer truthfully all questions asked of you as potential jurors to help you God?
Have a seat, folks. 2:27. Okay, great. All right, good afternoon, folks. First of all, welcome back. I know some of you came in early at our request, and I have to apologize. Frankly, what we had was an elevator issue that prevented us from getting into the courtroom, and that's why we kept you waiting. We do apologize for that. I do appreciate everyone showing up early. We're trying to give the case the time and attention it needs while at the same time moving this along so you can be released as soon as we can. So you're here for the second day of jury selection. As I told you, this is a capital case. It is a death penalty case, meaning death is a possible sentence in this case. So what we're doing today is I'm going to give you some more information about the case. I'm going to give you some instructions and explain to you a little bit more about the case. The information you're being given is necessary for us to be able to talk to you today and have individual conversations with you. Once I've instructed you, you're going to go back in the jury room. We're going to bring you out here one at a time to answer questions. As I said, we're going to try and get you through here as quickly as possible today. As I told you all, this is a capital case. And what that means is if certain things happen, the death penalty becomes a possibility in this case. Because we need to know that you can do your job if it becomes the death penalty becomes an option in the case, we have to go through this process. So I'm going to explain a little bit more to you about what the charges are, what the process is, and the whole goal of this is to find out whether or not you all can do your jobs as jurors in this type of case, should it become necessary. I'm going to start by telling you that Mr. Loyd has been charged by indictment. This is the indictment. It's a copy of it. Indictment, as you can see, it's pieces of paper that tell Mr. Loyd what he's charged with. You have to tell people what you're accusing them of doing, what crimes you're charging them with. We do it this way, by indictment. Indictments are not evidence of guilt. You can't use them as evidence of guilt. The other way of saying that is just because somebody's been charged with a crime doesn't mean you can assume that they're guilty of it. In fact, Florida law requires the exact opposite, which is that you be able to presume him innocent until and if the state proves he's guilty. He has been charged in this case with first-degree murder with a firearm of a law enforcement officer, attempted first-degree murder with a firearm of a law enforcement officer, aggravated assault with a deadly weapon, carjacking with a firearm, possession of a firearm by a convicted felon. It is the first count, first-degree murder of a law enforcement officer, that is what we call the capital count. That is the only count that if he's convicted of it, the death penalty becomes a possible sentence in this case. So let me start by explaining to you all how these cases are tried. There's two phases to these cases. The first phase is what we call the guilt phase. The guilt phase is where the jury determines whether or not Mr. Loyd is guilty of the charges against him. So your job as a juror in the guilt phase is you're going to sit in these chairs, these jury chairs. You're going to listen to the evidence that is presented to you. Evidence comes in several forms in trials. Witnesses will be testifying. They sit right next to me in this little box right here so that you can see them and hear them. The attorneys have the right to examine and cross-examine them, which is a fancy way of telling you they have the right to ask them questions. All right. There's also physical evidence that may be introduced, videos, photographs, documents. Jurors must be able to see them, understand them, and hear them. At the end of the presentation of all of the evidence in the guilt phase of the proceedings, when you're trying to determine whether or not someone is guilty, I'm going to give you the jury instructions. I'm going to read them to you, and I'm going to give them to you in writing. Jury instructions are the law that the jury is required to follow in the case. It's not optional, it's a requirement. It is the law. The jury determines what the facts are. The court tells you what the law is. You all take the facts and apply it to the law and reach verdicts. All right? The guilt phase of capital cases is conducted the same way as all criminal cases. You're going to be asked to return a verdict of guilty or not guilty on all the counts. Your verdict must be unanimous on all of the counts, meaning each juror must agree on each count either to acquit or convict. The burden of proof on the state is the same as in all other criminal cases. It is proof beyond a reasonable doubt. The instruction you receive on reasonable doubt will be identical to the instruction that is given in all criminal cases. The burden on the state is not higher because of the possible penalty. When you're deciding guilt in phase one of the case, you will be instructed to ignore the possible sentence for this phase. In other words, we ask jurors to decide whether a defendant is guilty or not on the charges, including first-degree murder, on their own merits, and you will be told to disregard the possible consequences of your verdict. The only question you're to answer during the guilt phase is whether the defendant is guilty of murder in the first degree, as well as the other offenses charged, or guilty of a lesser included offense, or not guilty. And we expect you to carefully consider the facts before you reach a decision. The fact that a defendant might face a death penalty is to play no part at that stage of the proceedings. If and only if the jury returns a verdict of murder in the first degree, the jury then reconvenes for phase two of the trial, which is for the purpose of rendering a verdict as to which sentence, death or life imprisonment without the possibility of parole, should be returned. That is what is known as the penalty phase. If that happens, I will be giving you the instructions and rules for penalty phases in detail. Today, I'm just giving you an overview because it's really all you need for the purpose of answering questions today. Because the death penalty is reserved in Florida for one class of crimes only, and that is murder in the first degree, the legislature has created special rules for juries to consider in reaching a verdict in the penalty phase. The legislature recognizes that not all first-degree murder cases deserve the death penalty, so they created a list of circumstances which juries are to consider in reaching a verdict in a death penalty case. The circumstances the prosecution relies upon are called aggravating factors. The ones the defense relies upon are called mitigating factors. The aggravating factors are required, the state is required to prove them beyond and to the exclusion of a reasonable doubt, and they are limited to 16 in number. There's 16 of them, and they're statutory. The mitigating factors do not need to be proven beyond a reasonable doubt. They only need to be proved by the greater weight of the evidence, which is a lesser standard. Mitigating circumstances are not limited by statute, and they can include anything that is related to the defendant's background, character, or the circumstances surrounding the offense. They are offered as a basis for a verdict of a sentence of life in prison without the possibility of parole. Life in prison without parole in the state of Florida means exactly that. The defendant will die in prison. We do not have parole in the state of Florida. Now, before you may vote that the court impose a sentence of death, the state must prove at least one aggravating factor beyond a reasonable doubt. They can prove more, but at least one has to be proven beyond a reasonable doubt. If the state does not prove at least one aggravator beyond a reasonable doubt, the only possible sentence is life without the possibility of parole. The vote on that must be unanimous. Every juror must agree they've proven at least one aggravating factor before you can go on to the next phase. So what the penalty phase looks like is another trial. The state's going to put on evidence of aggravators. The defense is going to put on evidence of mitigators. Once all that evidence is presented, I'm going to give you the jury instructions, the law that needs to be followed in this phase of the proceedings. You're going to go back in that jury room with your fellow jurors, the same jury room you've been in now. And what you're going to do is you're going to weigh the aggravating factors and the mitigating factors. Now, the weighing process is not mathematical, it's not mechanical. You don't add up the aggravators, add up the mitigators, and say, well, this side has more, so they win. That's not how it's done. Weighing means that each juror individually has to assign to each aggravator and mitigator the importance, the weight that they give it. And you may differ in your opinions on this, all right? One of you may find an aggravator to be very important to your decision. Someone else may say, that doesn't really factor into my decision. Same thing with the mitigators. You may find one critical to making your decision. There's others you may say, this doesn't really sway me one way or another. I don't think this is important. It's up to each one of you, but you have to weigh each aggravator and mitigator. When you're done with all of that, then you're going to take a vote on this. Now, regardless of your findings in this respect, you are never compelled nor required to vote for a sentence of death. The final step in this phase of the trial is for each of you to determine whether the defendant should be sentenced to life imprisonment without the possibility of parole or death. The court may not impose a sentence of death unless each juror individually finds the defendant should be sentenced to death. The vote for death must be unanimous. The vote for life does not need to be unanimous, all right? Even when death is a possible sentence, each juror must independently decide whether life imprisonment without the possibility of parole or death should be imposed. Regardless of your prior findings, the law never compels nor requires any juror to determine the defendant should be sentenced to death. Any single juror has the right to vote for a sentence of life imprisonment without the possibility of parole. If after deliberating, the jury unanimously agrees that the appropriate sentence is death, then your verdict may be for a sentence of death. If the jury does not unanimously agree that the appropriate sentence is death, then your verdict must be for a sentence of life imprisonment without the possibility of parole. So I told you this is a very broad outline of how these penalty phases are conducted. If you ended up in one, you would get detailed instructions on all of this. Let me also say one other thing. The fact that I'm talking about the death penalty is not to be taken by you as any indication one way or another as to whether or not this is a case which justifies a death penalty. I don't know that, and you don't know that. I'm only discussing that because it's a possibility. It doesn't presuppose anything. We just need you to be ready to do it if you have to do it, so we need to find out if you can go through this process. And let me explain something else about the process. The penalty phase requires an open mind, meaning you can't be sitting in the jury box thinking, I've convicted him of first-degree murder, intentionally killing another person with no legal justification. It's not self-defense, it's not insanity, it's not anything. That is what conviction on first-degree murder is. And so I'm just going to sit here and listen, pretend I'm listening, and then I'm going to vote the way I was going to vote anyway for life or death. That's not what you have to do. The penalty phase requires an open mind. It requires you being willing to listen to both sides, absorb and process that information. Doesn't mean you have to accept it all when you're weighing it. It doesn't mean you have to believe it or not. It just means you have to be open to it and not have made a decision until you've heard all of the evidence in the case, all right? We're going to be asking you some questions about the death penalty. I'm going to tell you what some of them are just so you have some time to think about it. We are going to be asking you about your position on the death penalty. Whether you're pro or against the death penalty, we're going to be asking you if you are someone who regardless of what the law is, what the evidence or the facts are, could never impose death in a case. And on the flip side of that, we're going to be asking you if you are someone who, upon convicting a person of first-degree murder, intentionally killing another person, the only sentence you would consider would be death. And we're going to ask you whether you can go through the process I just described, the weighing and all of that, with an open mind. Again, those are a few of the questions that you're going to be asked today. Let me switch gears to insanity. The defense has raised, Mr. Loyd has raised a defense of insanity in this case. This would be in the guilt phase of the case, where you're voting whether or not he's guilty. There is a jury instruction on this that's very detailed, but today, for today's purposes, I'm just going to read you the definition of insanity. A person is considered to be insane when he had a mental infirmity, disease, or defect, and because of this condition, he did not know what he was doing or its consequences, or although he knew what he was doing and its consequences, he did not know it was wrong. The defense has the burden of bringing forth and proving defenses. So this defense would have to be proven by the defense, not the state, and the burden is clear and convincing evidence. We are going to be asking you about your ability to accept this type of defense and listen to it with an open mind. So you might want to think about that a little bit. And then lastly, I'm going to read you a statement of the case. On the morning of January 9th, 2017, defendant Markeith Loyd is alleged to have entered the Walmart store at 3101 West Princeton Street. Mr. Loyd had an active warrant for his arrest. Orlando Police Lieutenant Deborah Clayton attempted to take Mr. Loyd into custody on the information she received regarding Mr. Loyd's involvement in the Dixon homicide, when it is alleged Mr. Loyd shot and killed Lieutenant Clayton following an exchange of gunfire, before fleeing the Walmart and eventually being apprehended about a week later. Mr. Loyd's trial for the killing of Sade Dixon and her unborn child began on September 27, 2019, and concluded on October 23, 2019. Mr. Loyd was convicted and sentenced to life without the possibility of parole. That last paragraph I read to you all about Ms. Dixon and the unborn child, she was pregnant at the time. That cannot be used by you to determine whether or not he's guilty in this case. These are two separate cases. State has to prove guilt independent of that. That can only be used in the penalty phase. We will be asking you some questions about your ability to follow those instructions. All right, folks, I'm going to ask you some questions. For these, all I need you to do is raise your paddles. Once I call out your number, you can put the paddle down. How many of you have heard about this case? All right, so I have 50, 54, 1, 2, 10, 23, 27, and 2. Of those of you who've heard about the case, how many of you have formed an opinion as to Mr. Loyd's guilt? 23. Anyone else? 2. Is that a yes, no, or maybe? You're kind of doing this, so, okay. A 2, all right. Anybody else I missed? There's 2 so it's the 2 from panel 10, not the 2 from panel 8, or 9, sorry. There's a lot of panels in here today. Next question. Is there anyone in this group who has a religious, moral, or personal objection to the death penalty such that you would never be able to consider the death penalty as an option? Juror in seat number 1. Okay, hold on. All right, from panel, what panel am I on? 8? From panel, I'm on 8. From panel 8, I have 49 and 50. Thank you. From panel 9, I have 1, 13, 17. And from panel 10, I have 2. All right. Flip side of that question, is there anyone on the panel for whom, if you convict someone of intentional first-degree murder, you deliberately murdered someone without any legal reason to do so or justification for it, you believe that the death penalty is the only appropriate sentence? All right, from panel 9, I have 27 and 35. Anyone else? 23, are you in or out on this one? You don't know. Okay, so I'm going to put you as in for right now, but we'll be asking you more questions. So, and she's from panel 9 also, so 23. Anybody I missed? All right, folks, I'm going to send you back into the jury room. I'm going to start calling folks out. What juror number are you, 50? 49. All right, if you'll stay in the room with us. Everyone else, head for the jury room. I'll get you through here as quickly as I can, folks. Thank you very much. All right. Good afternoon. How are you?
Good.
Okay. So, you're juror 209, correct?
Yes.
Okay. All right, let me ask you a few questions. Let me start with this. Well, first, let me tell you this. We're going to be asking you questions, myself and the lawyers. There aren't any right or wrong answers to these questions. The point of the questions is to figure out whether or not you can do your job in this type of a case, okay? So the only correct answer is the truth. Don't worry about what your answer is, just tell us the truth. You indicated that you have a religious, moral, or personal objection to the death penalty. Is that correct?
Yes.
Which one is it? Is it all of them, one of them?
I'm not okay with the death penalty.
Is it a personal belief of yours?
Yeah, I'm Catholic, so I wouldn't feel comfortable making that type of decision.
Okay. How long have you had that belief?
Since I was, I guess, of age, from what I can remember.
All right. Is your belief, okay, is your belief so strongly held that regardless of what the law is, you could never vote for a death penalty? I can't hear you. I'm sorry, you've got the mic way over here. Okay, go ahead.
I also don't believe in the law. Like, I don't trust it. Like, whatever evidence is presented to me, either by the defense team or by the prosecution team, I'm gonna have doubts about it.
Okay. State.
Remove, Your Honor.
Defense. All right, thank you, ma'am. You're free to go. Juror in seat number 50 from panel 8, please.
In the restroom, Judge.
Okay, while I'm waiting for that one, I've received a notification of juror in seat number 38 from this panel, the gentleman who was having the PET scan. He is unable to serve. I have a note from a doctor that, once again, I cannot print. Things are going really well in this courtroom. So it's up here on my screen if anybody wants to read it.
No, thank you.
All right, so juror in seat number 38, who is juror number 246 from panel 8, is being excused for medical reasons. Is there any sign of 50? Because I can move on to the next one.
What's your next pick if 50's not ready?
If 50's not ready, give me juror in seat 54, please.
50? Yeah.
All right. Good afternoon. How are you?
Good, how are you?
All right. Have a few questions for you. There aren't any wrong, right answers to this. The point of the questions is to find out if you can do your job as a juror. We need to know that. You need to know that. So the only correct answer is the truth. Let me start with you indicated a couple of things. Number one, that you know something about this case. Is that correct?
Yes.
I'll get back to that in a minute. But secondly, you indicated that you have a religious, moral, or personal belief which meant that you could never vote for death. Is that correct?
Yes.
Which one is it? Is it religious, personal, or moral, or all three?
Kind of all three, to be honest with you. It's something that I just don't know for sure that I could make the choice. I think I don't know. It's just a heavy weight to bear, so I'm just not sure that I can make the choice.
All right, let me start with, how long have you held this belief? Well, you know what? Tell me what the belief is. What is your position on the death penalty?
I don't know. I'm really kind of in the middle on the death penalty. I think in certain situations, I understand why it's used.
Okay.
And I understand, I think living life in prison is a death penalty in itself too. So I don't know. I'm kind of on the fence about it all.
Okay. So, you heard me describe what a juror has to do in this case, all right? You have
Yes.
to have an open mind about, you're never required to vote for death, but you have to be able to consider it, and if that's where the vote leads you, you have to be able to vote for that. Again, you're never required to vote for it, and I don't want you to think that, but you have to at least be able to fairly and openly consider it. So the question, and you're the only person who can answer this question, is, do you believe that you could fairly and openly consider a death sentence, and if you believe that the evidence and the law led you that way, you could vote for it?
Yes, I do.
Okay,
I think I could.
so tell me what you know about Mr. Loyd's case.
Pretty much just only what you've read so far. That's the same thing as I heard it was a shooting of a police officer and then a mother and unborn child.
Okay,
That's all I've heard about it.
where'd you hear it?
Coworkers.
And what else did they say about it?
My boss is convinced that he's guilty. So
Okay.
I did hear that. I've heard that people have said that.
Do you like your boss?
I do. I do.
You have to be careful because it's being recorded.
Yes, I do like my boss.
I don't want you to say anything that could get you in trouble. And the question I'm actually asking you is your boss someone that you respect who would have some influence on your opinions?
Probably. I was trying to not hear anything about any of the case because when I first walked in, I didn't know anything about it. But when I told work I'd have to serve jury duty again, everyone just started talking, and I tried to not listen to as much as possible. But that is what I heard, and I unfortunately do think it puts a thought in my mind of potentially respecting that opinion.
Okay. So jurors have to begin trials presuming someone to be innocent until and if the state can prove them guilty. You know what? Some folks can do it and some folks can't. So which one are you?
I think I could. I feel like I'm pretty open-minded, and I do try to look at facts and both sides. The only downside of that is I would say I'm a very emotional person. So trying to remove the emotional aspect of it, I think is something that would be difficult for me, and to not try to include any of the other information that we know about the case without letting that emotion conflict with my opinions.
Right, so by that you're talking about the previous conviction for the murder of Miss Dixon and her unborn child.
Yes.
All right. You can't consider that in the guilt phase. You can in the penalty phase, but you can't in the guilt phase.
Okay.
Are you telling me that you have some doubts about whether you can put that aside in the
Yes.
guilt phase?
I do.
That it'd be floating in your head thinking, he did that one, he probably did this one.
I do, yes.
Okay, thank you. State.
We move, Judge.
Fence. Yes. Mhm.
Hello.
Hi.
You heard the judge mention that Mr. Loyd has pled not guilty by reason of insanity in this case,
Yes, I did.
which means he's saying he did it, he's just not guilty because he was insane at the time.
Right.
Does that make sense?
Yes, it does.
And so the question is more so, understanding he's already been convicted of this other crime, do you think you could still consider whether or not he's not guilty by reason of insanity in this case? Does the distinction make sense what I'm trying to get at?
Kind of, if you could explain it a little bit more.
Sure. He's not disputing that he's the person that pulled the trigger.
Okay.
Okay, not guilty by reason of insanity. The judge gave you a little bit of an overview saying, it's somebody who doesn't know what he's doing or can't make his behavior conform with the law, basically, right? You're gonna get way more instructions if you're selected, okay?
Right.
But understanding that he's pled not guilty by reason of insanity versus saying, I didn't do it, I don't know anything about it, do you think that you could hold the defense to our burden of proving him not guilty by reason of insanity, even though you know he's already been convicted of another murder?
Yes.
Okay, I have nothing further.
Let me see the attorneys at the bench. I'll be right with you, ma'am. Give me 1 second, ma'am. All right, let me ask you a few more questions. Okay. So you said you can't put, don't let me put words in your mouth, okay? I'm just trying to figure out what you're telling me. I need to be very clear on what you're saying.
Yes.
You cannot put the murder of Miss Dixon and the unborn child aside in deciding guilt, but it would not affect your ability to decide whether whether this defense had proven Mr. Loyd was insane or not?
Yes, I guess that's what I'm saying. I think I'm partially like the emotional side of it is, I don't know, I feel like I would definitely let the other trial influence that, because if it happens twice, I feel like that's like where my thought process would go. If it can happen once and it happens again, like, is it insanity the whole time? Is it, insanity in this case only? You know what I mean? I think that's where my mind would, that's where I would question at least.
Okay. So let me ask you a different question, which is this. Let's say you didn't, at the end of the case, you find him guilty of first-degree murder beyond a reasonable doubt, all right? So now we're in a penalty phase. Mm-hmm. You have to be able in a penalty phase, like I told you, to consider the aggravators, consider the mitigators fairly and openly, and then weigh all of that before you reach a decision. If you reached a penalty phase in this case, would you be able to fairly and consider and openly consider aggravators and mitigators, or would you be thinking first-degree murder of a law enforcement officer, I'm voting death? I have two different questions for you, so that's the first one.
Okay. I don't know. I think I would struggle giving the death penalty. I do. I'm not necessarily for or against it, but I don't know that I personally could say, like, I want to vote death on someone and make that choice.
And so would that change if it's first-degree murder and he's previously committed this murder of Miss Dixon and her unborn child? Does that change your answers in any way?
No, I don't think so.
Right, so in order, again, like I told you, you never are required to vote for death, but It's the end of the case. You've heard all the evidence. You've heard the aggravators. You've heard the mitigators. You're back in the jury room. You're weighing all of this. If the evidence, the law, and your thought process, if you believed that the appropriate sentence was death, could you vote for death?
I don't think so.
Okay. State.
We renew our motion.
Defense. All right. Ma'am, I think on the issue of the death penalty, I'm going to, on the ability to fairly weigh a death sentence, I'm going to excuse you as a juror in this case, but we really appreciate your openness and honesty.
Thank you.
Have a good day. Thanks.
Thank you very much. I appreciate it.
I'm not on that right now. Mine's working, I think. Can you type something, please? I'm sorry? All right, it's back on again, thanks. All right. We're good. The transcript wasn't running, and now it suddenly started running again. Juror in seat number 54, please.
Thank you.
Good afternoon, how are you?
Good, how are you?
Hanging in there.
Excellent.
All right, we have some questions for you, sir. There aren't any right or wrong answers to these questions. As I told you, the point of the questions is we're trying to determine whether or not you could do your job as a juror in this type of case. We need to know that, you need to know that. So the only correct answer is the truth. You said you'd heard about this case, is that correct?
Yes.
How much have you heard about it?
To the, I guess when it happened, and then the manhunt, and to the end.
What do you mean till the end?
When he was found.
Okay. What do you remember about when he was found? I'll start backwards. What do you remember about when he was found?
I just remember him being brought in, and on TV, just being handcuffed and brought to jail.
Anything else you remember about that?
No.
No?
No.
All right, how about before that? Like I said, I was going to go backwards.
Yeah.
What do you remember about before that?
Just the female officer was shot. Another officer was killed in transit, I believe, and going to the scene. Yeah, and that's about it.
Since that time, have you watched any coverage of the case?
No, I mean, if it's come on between, on Spectrum News or something like that, but not that I've tuned in to see it.
Anything that you read? Anything on Facebook? Anything like that?
No,
No?
no.
At the time this was all going on, were you talking to friends and family, coworkers about it?
At the time it was going on, yes.
Okay. Do you remember what the conversations were about?
No, just I think normal, just, kind of unbelievable type stuff, unfortunate stuff, things like that.
Okay. Did you form an opinion at that time as to whether or not Mr. Loyd was guilty?
Yeah, I have to say, yeah, from news coverage and everything, yes.
What was that opinion?
That he was guilty, and they were looking for him.
Right. Jurors in all criminal cases have to be able to presume a defendant to be innocent until and if the state can prove he's guilty beyond a reasonable doubt.
Yes.
Sometimes folks can do it, sometimes they can't. Do you think you can do it in this case, or would you start out thinking he's probably guilty?
No, I'd look at the evidence.
Okay. So I'm going to give you 3 scenarios. You tell me which one applies.
Okay.
And if none of them apply, tell me that.
Okay.
All right. The first scenario, it's the first day of the trial. You're sitting in that jury box, haven't heard anything, you're just waiting for us to start. And you're sitting there and you're thinking, this man's innocent, the state needs to prove to me that he's guilty beyond a reasonable doubt. Scenario number 2, you're sitting there thinking, he's probably guilty, but I'm willing to listen and see if he's not. Scenario number 3, I think he's guilty, but maybe he can convince me otherwise. Do any of those 3 apply to you?
2 and 3 are a little similar, so I think 2.
Okay, thank you. State?
We move, Your Honor.
Defense? Thank you. All right, sir, thank you very much. You are free to go. I'm excusing you from this jury.
Thank you.
Thanks. All right, from panel number 9, juror number 1. Good afternoon, how are you doing?
Good afternoon, God bless.
All right, I know this is not the most comfortable situation in the world for you to be in. Try to relax as much as you can. I'm going to be asking you some questions, and so are the lawyers. There aren't any right or wrong answers to these questions. The point of the questions is to find out if you could do your job as a juror in this type of case. So the only correct answer is the truth, okay?
Okay.
So let me start with, you said you have a personal, religious, or moral objection to the death penalty. Is that correct?
Yes, correct.
And which one is it?
The coastal, we don't judge nobody for their actions. You know?
So you don't, your religion prohibits you judging other people?
Yes.
Is there any case, regardless of what the evidence, the law, the facts were, in which you could vote for the death penalty if you thought it was appropriate?
No, I don't vote for the death penalty.
Okay. State?
We move, Your Honor.
Defense? All right, thank you, ma'am. We appreciate you coming in. You're excused as a juror.
Thank you so much.
That's, you're juror 786, right? Yeah. Okay, she's gone.
Here she is, Judge.
Thank you. Juror in seat number 2, please. This is still panel 9.
I'm sorry, 2?
2, panel 9. So I have 2 2s.
Just in case Your Honor may have written it down wrong, I don't think juror in seat 2, panel 9 had any objections. It was seat 2, panel 10.
Seat 2, panel 9 had knowledge. She's
Oh, I'm
being called
sorry.
in here for knowledge.
Yes,
yeah.
Your Honor.
But no, I appreciate it because it is getting a little
Yes, Your Honor.
confusing.
Thank you.
Yeah, thanks. I'm sorry? I'll try, but may or may not happen. Good afternoon, how are you?
Good afternoon, Your Honor. I'm good. How are you?
I'm well, thank you. You're in seat number 2, but you're panel 9, so you're juror 723?
Yes, ma'am.
Okay, I just have to keep straight who I'm talking.
Understood.
I'm going to have some questions for you. The attorneys may have some questions for you. There aren't any right or wrong answers to these questions, ma'am. The questions are being asked just to determine whether or not you can do your job as a juror in this type of case, all right? So the only correct answer is the truth, okay? You said you had some knowledge about this case. Can you tell me what that is?
Just that it occurred. It was in the news, just mainly headline stuff.
All right. And the stuff that you're talking about, was this when it first happened or throughout the years, or what are we talking about?
No, just pretty much when it first happened. I used to travel a lot for work, and I don't think I was in Orlando when this first occurred. So it would have just been that it did occur, and then probably
Yeah, no, I think it was just when it first occurred. I didn't really follow anything afterwards. I did not follow anything afterwards.
Did you have any conversations with anyone about it? Co-workers, family, friends, anything?
Not that I recall.
And did you form an opinion about whether or not Mr. Loyd was guilty based on what you were hearing?
No, because I didn't follow the cases or anything.
And subsequent to that time, you haven't heard or read anything?
No.
Do you have a position on the death penalty, ma'am?
How so?
Well, are you someone who is against the death penalty, for the death penalty? Have you ever thought about it?
Yes. So with regards to the death penalty, I am more so with regards to following the law. I'm not against it. I'm not, super pro, super anti-death penalty. I just would be whatever the circumstances are of the case, of the situation, and how it applies to the law.
Okay. Let me ask you some specific questions about the death penalty then. The law in the state of Florida requires, number one, a conviction for first-degree murder.
Yes, Your Honor.
Premeditation, intentional killing, no legal justification. That's first-degree murder, all right? So you set out to kill this person and you had no legal reason to do so. It's not self-defense, it's not insanity, there's nothing there, all right? The jury has convicted that person and found them guilty beyond a reasonable doubt. You with me so far?
Yes, ma'am. Yes, Your Honor.
All right. So at that time, just hearing that, conviction, no reasonable doubt, first-degree murder, are you someone who thinks that the sentence for that should be death?
I guess I would want to know the circumstances of everything.
All right.
If everything met, the determination of that, I would have to.
You can't say right now is what you're
correct. Yeah.
All right. If I add to that the fact that it's a law enforcement officer, would that change your answer in any way?
I would still want to know the details of the case.
All right. And then if I add to that a conviction for a previous murder, would that change your answer in any way?
Still, again, the details of the case.
Okay. That is Florida law. All right. As I explained to you, if you end up in a penalty phase, there's another trial. State's going to put on the aggravators. The reasons they believe you should vote for death. Defense is going to put on mitigators. The reason they believe you should vote for life without parole. You've got to listen with an open mind. You have to be willing to absorb that information and process it. Can you do that?
Yes, Your Honor.
All right. And then you're going back in that jury room to personally weigh the aggravators and mitigators. If that process led you to believe that the sentence should be life without the possibility of parole, can you vote for that?
Yes, Your Honor.
And if that process led you to believe that the sentence should be death, could you vote for that?
Yes, Your Honor.
All right. The insanity defense, as I told you, Mr. Loyd has raised the defense of insanity. This would be in the guilt phase. You're trying to decide whether he's guilty or not. The burden's on the defense to prove that. But if at the end of the guilt phase, states put on their evidence, defense has put theirs on, you were convinced by the defense's evidence that Mr. Loyd was insane, could you return a verdict of not guilty by reason of insanity?
Yes, Your Honor.
And then my last question is, can you put aside the murder of Ms. Dixon and her unborn child during the guilt phase and not consider that in determining whether or not he's guilty of these charges?
Yes, Your Honor.
All right, thank you, ma'am. I don't have any other questions for you, but I'm sure the attorneys do. Mr. Williams, you may inquire.
Thank you, Your Honor. Good afternoon.
Good afternoon.
So we have the answers or responses that you gave to the questionnaire that you filled out.
Yes, sir.
I'm going to ask you a couple of questions about those responses. You have close friends or close friend or related to a law enforcement officer?
Yes, sir.
Is that tied to your employment?
Both. Yes.
So you have friends.
I was previously a police officer in Gainesville.
Okay, and how long did you do that?
Just under a year.
And did you go from that to your current role?
No. I mean, essentially, yes, but not directly.
Understood. I have to take notes every now and then so I can remember, so please forgive me. people who you do not know, well, can you give us a quick summary of what you do currently, if you're allowed, because I saw what it is, and I don't want to get you in trouble.
I appreciate that. I do background investigations for the government, for anybody that needs a security clearance, like military, defense contractors, that type of
I
thing.
completely understand now. Okay. And how long have you been doing that?
Close to 15 years.
Who is close to you in law enforcement that is not related to your employment?
Like family or friends? Or
Yes, ma'am.
Okay. Friends, it's Dr. Ross Wolf with the Orange County Sheriff's Office.
You don't need to give me the exact
Oh, okay.
names. I'm just
Sorry.
mean, what's their role in law? I didn't clarify that. It's my fault. What's their role in law enforcement and the nature of your relationship?
Okay. The person is a reserve, and he was my mentor advisor through college. And another person I stayed friends with after college. Different person stayed friends with after college. Do you need their employment or what? Sorry, what
agency?
information do you need, sir?
What agency do they work for?
Orange County Sheriff's Office.
Okay. Go ahead. Anybody else?
There is another friend that I went to the academy with. Kind of brief contact there with the Alachua County Sheriff's Office. And you're looking for law enforcement?
Yes, ma'am.
Okay. There's nobody that really sticks out to me at this point that I'm friends, that I consider a closer friend I maintain contact with. That is local law enforcement that I can think of right now.
Yes, ma'am. Anything about your relationship with those individuals or your current role or your prior role in Gainesville that you think would prevent you from being fair and impartial in this case?
Not at all. I actually think my current position enables me to be completely impartial, because with investigations, I see all the time that on paperwork and what you do after the investigation and the evidence that you get can be 180 degrees from what was on paper.
Yes, ma'am. So you told us that your position on the death penalty, and I'm summarizing essentially, was more in regards to following the law.
Yes, sir.
So you're not for or against capital punishment as a principle?
Correct.
I think I heard you say that after having a description from the court about the process, that you could vote to impose either sentence or have either sentence imposed based upon where the facts in the law are.
Yes, sir.
Do you remember the court discussing with you the weighing of aggravators and mitigators?
Yes, sir.
So the key part to that is your willingness to give meaningful consideration to both. Ultimately, you decide how important one thing is. That's what that weight part of it was. And I'm not trying to talk down to you. I just know that this process can be confusing.
I appreciate that.
But before making any decision, you have to be willing to consider whatever you hear, regardless of where you are in the life. Right?
Yes, sir.
Is that your understanding?
Yes, sir.
Regardless of what aggravators you hear and how emotional or strong you may feel about them, could you withhold judgment and give meaningful consideration to any mitigating circumstances that you heard about Mr. Loyd's life, background, or defense in regards to any potential penalty that may be imposed if he's convicted of first-degree murder?
Yes, sir.
That was a long question, I know, I apologize. Is there anything about your, well, let me back. I should have talked about insanity first, I apologize. Because of that defense and its nature, I need to ask you if you or anyone personal close to you have dealt with mental illness in your life.
In what fashion? What do you mean?
Suffer from it, gotten treatment for it, study it, anything that would give you insight into the concept of mental illness.
Well, I mean, I deal with that with my job. You know, we do have subjects that are declared mentally incompetent, and
Okay.
I wind up reviewing a lot of medical records with my job.
That's the kind of information I'm looking for. Given your contact with that topic in your job, do you believe that mental illness is a real thing?
Yes, sir, definitely.
I ask that because there are portions of our society and community or people in them who don't believe that.
Right. Correct, sir.
Given that belief, do you think that you could fairly weigh and consider any information or evidence presented to you on the issue of whether Mr. Loyd is not guilty by reason of insanity?
Yes, sir.
And if it were proven to you, could you find him not guilty by reason of insanity?
Yes, sir.
My last question, ma'am, is there anything in your background or life experiences that you think we should know about you, given that we're trying to select the most fair and impartial jury that we can for this case? You've already given us a couple of examples, the insight into what you do. Anything like that, other than what we've discussed, that you think we should know?
No, it really was just what I had mentioned earlier. Is I understand I have a obvious background in criminal justice, law enforcement, but with my current job, it is weighing the facts. It's weighing the evidence. It's, you know, going over that in minutia, in detail, to come out with the best information to be able to make a determination.
And I should have asked you this. Your juror information says you have never been a juror before.
Correct.
Have you ever been called up like this?
I have.
On multiple occasions?
Yes.
That's why I wanted to ask this question. On a scale of 1 to 10, 1 being you can't wait to get out of here and go back to your job and your life, and 10 being you're uber excited about the prospect of being a juror, where would you put yourself?
I would say in the middle. I think professionally, this is what I've learned about and you know, gotten schooling on and whatnot. However, you know, I am quite active, and I, you know, do have my own personal life. But I also think you know, being a federal employee, I am able to take off of work and be here for the required amount of time, where I understand that is hard or nearly impossible for most people. Yeah, I think I am interested, you know, and I think I would be impartial and interested. I think that's I would be interested, whereas I wouldn't just be here out of complete obligation and required to be here and hate, like you said, hating every minute of it. I think, yeah, I guess just kind of in the middle.
Yes, ma'am. Thank you. Thank you, Your Honor.
Thank you, Mr. Williams. Ms. Miller, remain quiet.
Hello.
Hello, ma'am.
Where you're currently employed is not a secret, is it?
No.
Okay, we've all been beating the Department of Defense, correct?
Yes.
Okay. You were previously a law enforcement officer with the Alachua County Sheriff's Office.
No, Gainesville Police Department.
Got it. Any other law enforcement agencies?
No. Not as a law enforcement officer. I worked for University of Central Florida Police Department. It was like I drove golf carts around.
Was that your job title?
It was awesome. Best job ever.
Driving golf carts around?
Yes.
Any other law enforcement agencies, either law enforcement or civilian?
No.
Okay. And you said that, my curiosity was piqued when you said that you went not directly, but essentially from the Gainesville Police Department to your current employment. What does that mean, please?
I moved from Gainesville back to Orlando because I have family and friends here and didn't come back here immediately into a job. So I worked at a home builder for a couple of years before getting into this job.
Gotcha. And I think you can probably appreciate why we ask some of the questions that we do, right?
Sure.
The goal is to find jurors who can be most fair for this case. And it's not a reflection on any particular juror. Everybody comes into this with their own background, walk of life, right?
Understood. Yes, ma'am.
And so I want to talk a little bit more about the victim in this case being a law enforcement officer, right?
Yes, ma'am.
And certainly it wouldn't be fair, I think you would agree, to the state if the jury was composed of Mr. Loyd's family, right?
Right, correct, ma'am.
And my understanding is law enforcement sees itself as a type of family. Would that be fair?
Yes, to a certain extent.
And so, I don't think anyone doubts your ability to follow the law, right? And all of those laws will apply to you if you are selected as a juror in this case. Right now, the oath that you took was to tell the truth. And so I am genuinely asking about your feelings, right? I want you to envision yourself being in the deliberation room, trying to decide if we've met our burden of proving Mr. Loyd not guilty by reason of insanity. And would you struggle to acquit him? Not guilty by reason of insanity is still not guilty of the crime of murder of a law enforcement officer, given your background.
Not if the evidence is there.
Okay. Same type of question about the penalty. So now you've convicted him. You've rejected that defense. He's been proven guilty beyond a reasonable doubt of the intentional, premeditated killing of a law enforcement officer. Thought about it, he meant to do it, and he did it. No legal excuse, justification, or defense. You're being asked to decide what the appropriate penalty is, life or death. Do you think you would be feeling pressure to sentence him to die because of your background?
Not at all.
Okay. Tell me what you're thinking.
Just that. I don't see why there would be any pressure to, or expectation of me or anybody to sentence him to death.
Okay. And maybe I'll just tell you what my fear is, right?
Sure.
So some folks that have background in law enforcement, related to law enforcement officers, feel pressure, like I have to go back to my loved one, my family and friends, who at some point are probably going to realize where you are, and they may question why you did something. And some people say, yeah, that wouldn't bother me. And some people say, yeah, I think that might creep into my mind, envisioning going to talk to my friends that you talked about in law enforcement and having to explain myself. Does that make sense?
Yes, ma'am.
Does any of that apply to you at all?
No.
Knowing someone has been previously convicted for another murder and is serving life in prison, does that make you feel that the appropriate punishment for this second murder, the only appropriate penalty, should be the death penalty?
No, ma'am.
Why not?
Because it's two different trials, two different situations. It's separate.
Okay. And you're exactly right. And the judge has instructed you, and she'll explain more, that because he's guilty of one other case doesn't mean he's necessarily guilty in this case, right?
Correct.
But you are allowed to consider that he's been previously convicted, Mr. Loyd, of another murder and is serving life in prison when deciding what the appropriate, considered an aggravating factor in Florida. With me?
Yes.
And again, some people say to me, listen, if I know he's already doing life for another murder, really that death becomes the only appropriate penalty here. Does that make sense?
I understand what you're saying.
Any of that relate to you at all?
No, ma'am.
Okay. Mitigation, right? Some of these aggravating factors are huge. The murder of a law enforcement officer, prior conviction for murder. And mitigation can be seemingly somewhat small. And so when we talk about being able to give meaningful consideration to something, I think you can appreciate this. It means hearing it, internalizing it, and it potentially, doesn't have to, but potentially having impact on what you think the verdict should be, life or death. Does that make sense?
Yes, ma'am.
So if I asked you if you could consider somebody experiencing the effects of racism and give that meaningful consideration as to life or death, do you think you could do that?
Yes, ma'am.
Okay. You will not be surprised to learn, or I suspect you won't be surprised, that sometimes folks have differing opinions on these sort of things. Fair?
Yes, ma'am.
And that's why death is never required, not in any case. And so, I hear you saying, I can follow the law, put these facts as the judge instructs, right? So if we're in the second part of this trial, and you're trying to decide if you're trying to decide the appropriate penalty, the first question is, has the state proven the existence of at least one aggravating factor beyond a reasonable doubt? Is that aggravating factor sufficient to warrant the death penalty? Does the aggravation outweigh the mitigation? And then the last question is death the appropriate penalty? And so even if all of these are yes, 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 you can always answer no to that last question. Does that make sense?
Yes, ma'am.
And so that's why we talk about feelings, because there really is no right or wrong answer. You apply the facts to the law and you vote your conscience. Make sense?
Yes, ma'am.
If one juror decides that life should be the verdict, then life will be the verdict. Are you okay with that?
Yes, ma'am.
And we talk about mitigation a lot. It is simply why one juror would choose life or not choose death, okay? And that's what another example, it could be simply a smile observed between the defendant and a family member. And for that juror says, I assign the weight of life to that, and I'm not giving a death sentence in this case, and that's okay. Mitigation doesn't have to be unanimous, and it can be unique to each individual juror. Make sense?
Yes, ma'am.
You are certainly not going to allow anybody else to bully or badger you into changing your individual moral assessment once you've reached one, right?
Correct, ma'am.
And you wouldn't bully or badger anybody else to agree with you if they had a differing opinion.
Correct.
May I have just a moment, Your Honor?
Yes, ma'am. All right, thank you. Either side need to approach.
No, Your Honor.
All right, ma'am. We're going to send you through to the final round of questioning in this case. And that means that if you'll hand your badge to the deputy, you're going to become a purple dot. Like I said, I use the colors to call people in because too many numbers. So
Yes, Your Honor.
we're going to give you a packet. In the packet is a slip of paper with a phone number on it to call to find out when you're supposed to report back. I don't actually know the date. I strongly suspect it's next week, but I'm not 100% sure. So if you'll call starting tomorrow after 5, eventually you're going to hear purple dots come in. If you don't hear anything, you're not being called in yet, all right? The day you come back, we're going to pick the jury and sequester the jury. So you'll need to have packed a suitcase, leave it in your car. If you need it, we'll have you go get it. If not, you can just drive home with it. There's also a sequestration packet in there that explains to you what it's like being sequestered, what the rules are, and gives you some suggestions about what to bring with you. And lastly, there's a letter for your employer telling them that you're coming back for one more day. Do you have any questions?
No, Your Honor.
All right, thank you so much. We'll see you next time. We appreciate your time this afternoon.
Thank you.
All right. Need this juror in seat number 10, panel 9. I'm sorry? Panel 9. It's juror 3374.
How's this?
Good afternoon. How are you?
Good afternoon. Is this okay? I echo.
Yes, we can hear you.
She said
It may be
present.
echoing a little to you, but we can hear you. All right. Have some questions for you, and then the lawyers probably are going to have some questions. There aren't any right or wrong answers to these questions. The point of the questions is to find out if you can do your job as a juror in this type of case. It's something we all need to know, including you. So the only correct answer is the truth. Let me start with, you said you had heard some things, you had heard about Mr. Loyd's case. Can you tell me what you've heard?
Up until you read that, I had read that. I do remember on the part and detention, I think must have been early evening because they broke Jeopardy to report it. That's all I remember.
Okay. Do you remember talking to anybody about this case? No? Okay. Did you watch anything after the arrest?
I don't intentionally watch the news, and I don't get newspapers, but that's the clearest into Jeopardy to detention.
Okay. Did you form any opinions as to Mr. Loyd's guilt based on what you saw or heard?
No.
Jurors have to be able to presume, in any criminal case, you have to be able to presume the defendant innocent until and if the state proves they're guilty beyond a reasonable doubt. Do you believe you're able to do that in this case?
I do.
All right. You're juror 3374, correct?
Yes, ma'am.
Okay, sorry.
The reason I think it's not clear, I'm sorry to interject, but had I been paying attention and watched a lot about it, I think I would have remembered a pregnant victim. I really think I would have remembered that. That's something that like would have stuck out. And,
Okay, it's okay that you don't remember. So, are you someone who has any strong opinions about the death penalty one way or another?
well, that's why I spend most of my time back there thinking, and I said it on reluctantly in favor. That reluctantly means I can't go in there and say, okay, first degree murder automatically deserves death. But if I imagine myself in that phase, assuming I got to that phase, that in my mind I imagine there's some gap between life without possibility of parole and death. And aggravating factors are trying to build a bridge over it, and mitigating factors are trying to knock out the steps, and eventually I'll be able to walk across. And I know that's the best way I thought about it is. But if anything matters, if anything's relevant to you, I think it's that in my mind, bridge towards death, not that I'm standing on death and mitigating factors have to move me away. It's the bridge. Mitigating factors go towards death, and the mitigating factors come back. And that's why I settled on reluctantly in favor, I guess, if that matters.
Okay, you have managed to answer all of the questions I would have asked you, and I appreciate that very much about the death penalty. I'm moving on to insanity. Your position is completely accurate as to what the law in the state of Florida is. The only question I would ask you is, if after all the process, you believed the appropriate sentence was life without parole, could you vote for that?
Yes.
And if you believed it was death, could you vote for that?
Yes. I imagine that if I'm in that phase, that, like I said, there'll be something that I'll remember, and as you said, I'll weight them, and I'll either be able to, justify that decision, or I won't.
Okay.
And I don't know what that's going to be or how it's going to happen, or if it does.
Today, all we're trying to find out is if you can do it. Later on, you'll find out more details, but.
I do, but I do right.
Okay. The insanity defense. Mr. Loyd has raised that. It is the defense's burden to prove it. But let's say you're at the end of the guilt phase when you're trying to decide whether or not he's guilty. If at the end of that phase, you were convinced by their evidence that he was insane at the time of the offense, could you vote not guilty by reason of insanity?
If I believed it, I guess I'd have to.
All right. And then my last question to you is, you remember I told you about the previous conviction for the murder of Miss Dixon and her unborn child?
Yes.
Is that something that you can put aside in the guilt phase? Because it has nothing to do with whether he's guilty of this or not.
Yes.
It can be considered in the penalty phase.
Yes.
Is there anything
That's
about...
a completely different crime, and nothing about it matters here.
All right, is there anything about that would... never mind, you've answered my questions. I don't have any other questions for you. State, you may inquire. Mr. Williams?
Thank you, Your Honor. Good afternoon, sir.
Good afternoon.
That bridge thing, I may steal that.
Okay.
Because that's pretty good.
I had a lot of time to think. I was,
Well, you used it wisely. The only real question I have for you about the death penalty, and the judge asked you, but I'm going to drill down a little bit more, is not in a theoretical sense while you're contemplating it and whether you could do it, but like in a real sense, understanding that if you're selected as a juror next week, you could be put in this actual position.
Yes.
Could you, if the evidence led you and the law authorized you in your mind, could you walk across that bridge and actually say, yes, I'm raising my hand and voting that a sentence of death be imposed upon another human being? Could you do that?
Yes.
And conversely, if it weren't proven to you, or you believed it was not authorized, or you just thought that it wasn't appropriate, could you vote for life in prison even if you really thought the crime was bad?
Yes.
Okay, thank you.
I think, okay. I think a conviction for first-degree murder is bad, and it seems that affects some, like I said, some measure of a gap between those two sentences that has to get bridged or not, but
And it's the party's job in this case to fill that gap for you with the information that you provided, and I assure you that will happen. But I have no, yes, sir. So when you were asking answering the judge's questions about insanity, unfortunately, we listened very carefully to everything you say, and you said that you could find Mr. Loyd not guilty by reason of insanity, and you said, I guess I'd have to. And I interpreted that to mean that if the law said it in your mind that you had to, that's what you would do.
no, she asked me that if I believed that, would I be able to say it? And that's why I said, I guess I'd have to, because if I believed that, then yes, I'd have to say that.
Okay.
If I'm convinced that insanity played a factor, that, yeah.
Understood. You clarified that for me.
Okay.
Because of the nature of that defense, I need to ask you a somewhat personal question, and that is whether you or anyone close to you have suffered through or experienced mental illness.
Mental illness? I don't know. My daughter was just diagnosed bipolar, but
Okay.
that's kind of like therapy, so I don't know.
That would qualify. And what I tell people is if you're not sure if you should tell us something that pops in your head, then tell us, and you did. So, is she getting treatment, did I hear you say?
Yes.
Okay. Is that helping, do you think? Or is it too early to know?
I don't know. I haven't spoken to her since Friday, because
Okay. So is that a recent thing?
my wife is kind of running interference with me.
Is it a recent thing, the diagnosis?
It was yeah. She used that to switch from a therapist to a psychiatrist in the event that they feel medication is necessary, but that's the only mental illness I have direct experience with.
Have you observed your daughter's behavior as a result of that mental illness?
No, she moved out 10 years ago, and she's on the north side of Lake Mary. So
Okay.
I saw her, like 3 times this year.
Understood. There are people in our community and society who believe that mental illness is not real.
Okay.
I take it from your responses and your personal experience that you are not one of those people?
I'm sure it's real.
Well, you say that, but I'm asking.
Psychiatrists exist, and
Okay. So you believe it's real?
insanity defenses exist, so I'm sure it's real. I don't know what you mean. They think it's not real.
There are people who think that mental illness is made up as an excuse or justification for people's actions.
Ah,
Does that make more sense?
yes.
Are you one of those people?
No.
I didn't think so, but given the nature of the defense, I need to ask, right? So I take everything that you're saying to understand you to mean that you could fairly weigh a defense of insanity and find Mr. Loyd not guilty by reason of insanity if it were proven to you.
Yes. And it has to be proven by them.
Very good. Yes, sir. That's what you were told.
That's it.
The last thing I'm going to ask you is there anything that we have not discussed in your background or life experiences that you think we should know about you, given that we're trying to select the most fair and impartial jury in this case, where death is a potential penalty?
Well, I don't know what to know.
So by way of example,
I'll just go quick.
Yes, sir.
went to FSU, majored in computer science, went in the United States Navy in 1995, 8 years in the nuclear power program, went to Naval Nuclear Power Training Command here in Orlando at the base that's now Baldwin Park, went to the Theodore Roosevelt, got out, went back to software, did programming and web development since 2001.
Okay. You were 8 years in the Navy, you said?
Yes, sir.
Okay.
Reactor technician.
Anything else?
Reactor technician. Pressurized water reactors.
Thank you for your service and answering my questions, sir. Thank you. I don't have any other questions.
Thank you, Mr. Williams. Ms. Miller, you may inquire.
Hello.
Good afternoon.
I think you and I might be Madam Court Reporter's worst nightmare, the speed in which we speak.
Is it fast? I've been accused of that before.
I don't mean it judgmentally. You'll see.
You should see how fast I type.
I think you probably get where we're going with this, that some people who hear about the intentional, premeditated killing of a law enforcement officer, that defendant thought about it, he meant to do it, and he did it. And there wasn't any legal justification, excuse, or defense. Some people feel very strongly that somebody who is guilty of that crime deserved the death penalty. Make sense?
Yes.
Is that you?
I know some of them. No.
Okay, why not? Why would, you said you know some of them.
It's slipping.
I know, they're terrible. Thank you for wearing them. Why is that not you?
Why is that not me? I thought about that too. And the Declaration of Independence says that we are endowed by our Creator with certain unalienable. The Declaration of Independence, this is what I came up with when I was thinking about it.
Okay.
The Declaration of Independence, although not a legal document and technically an illegal document at the time, says that we are endowed by our Creator with certain unalienable rights, and among these are life, liberty, and the pursuit of happiness. So
Slow down just a teeny bit.
okay, I figured since that was a quote, it was probably familiar.
You know what? Just to help out the court reporter, take off your mask, just pull it down.
Okay, I could.
Unless there's no one around you.
I'll go up.
Okay.
Okay, well, I got the Johnson vaccine if that matters.
If you're uncomfortable doing that, put it back on again. But if you're uncomfortable taking it off, put it back on.
I'm fine. If anyone else is uncomfortable, I'll put it back
You're
on.
fine. Go
Just run all the way down. So I think that the default position is there has to be something extra to justify the death, you know?
Sure. And
That's why.
And we call those aggravating factors.
Yes.
They're things that are intended to make a juror think death might be more appropriate in this case. And one of those is the murder of a law enforcement officer.
I see.
Does that make sense?
Yes.
And so certainly that is something that you can say, this makes me lean towards the death penalty.
Okay.
What I want to make sure of is that knowing that alone, you're still willing to consider the other side. And some people say, and there's truly no right or wrong answer.
Is that literally one of the 16 aggravating
Yes, sir.
factors? Okay.
Yes. And so that's where some people say, if I know that to be true, if I'm being honest with myself, I'm not going to be able to give meaningful consideration to mitigation or the
I see what you mean.
the circumstances in favor of life. Does that make sense? What do you think about that?
I think, just like the bridge I imagined in my mind, that it's my duty to consider all of the aggravating factors and all of the mitigating factors, and I have to justify to, not only to my conscience, but to the court, the people, and the defendant, that death is appropriate. And so that's, like I said, that's why I said reluctantly in favor, because that's got to be at least some small measure of leap for me.
Okay. And so sometimes, some of these aggravators are huge, right? It's the murder of a law enforcement officer, the defendant being previously convicted of another murder, right? And then I want to ask you about the effects of racism, which may seem small, but could be equally huge. And so do you think that you could consider meaningfully, and that you hear it, you internalize it, and it could affect your verdict as to life or death?
Racism? Hearing about racism in the courtroom, or
Hearing about the defendant being affected by racism.
Oh.
Tell me what your thoughts are.
If I had to improvise an answer without significant deliberation, I would say effect of suffering racism on the defendant would be on the insanity side, I guess.
Sure, it could
And
be.
not on the, yeah.
Well, it could be.
And not on the, was this, whatever higher measure of callousness, viciousness, or that pushes to death. You know what I mean?
Yeah.
Effect of racism on the mental state would be probably, something that would, I don't know if that makes sense.
No, it does. And so we're having this conversation a little bit in a vacuum.
Okay.
And we may never even get to the second part of the trial, right? If the state doesn't prove Mr. Loyd guilty beyond a reasonable doubt, or if we succeed in proving him not guilty by reason of insanity, you would never even be considering penalty, because he'd be not guilty,
Yes.
right? And so I don't want you to think because we're talking about penalty, I'm assuming we're going to get there. I'm not. This is just the only opportunity.
I'm not either.
Okay, I didn't think you were. This is the only opportunity I have to talk to you, and the law requires us to have this conversation now. So insanity is, right, it's a narrow legal definition, and the judge gave you some of those instructions, that a defendant could not decide between, or could not understand right or wrong, or could not conform his behavior to the law, right? And so you may hear about things affecting a defendant's mental health or mental illness that you don't think rises to the level of insanity, so you still found the defendant guilty,
I see.
but we're in the second part of this, and you could still give it consideration as to whether life or death are the appropriate penalty. Does that make sense?
Yes.
And so I'm just asking you if you think for you that is something you could do. The effects of racism, mental illness, even if it doesn't meet the definition of insanity, is that something you can consider when deciding whether life or death is the appropriate penalty?
I hope I'll remember and consider everything.
Yep. Well, you're going to be able to take notes if that's helpful. And you'll get all of the instructions read to you in much greater detail. Just a couple things. Death is never required. Not in any case. Not in the worst conceivable case you can imagine. Okay? And so the second part of the trial, looks like you want to say something. What are you going to...
She mentioned that.
Yep. Sometimes we repeat it. I repeat the judge. In the second part of this trial, the steps are, has the state proven the existence of one aggravating factor beyond a reasonable doubt? Is it sufficient to warrant the death penalty? Does the aggravation outweigh the mitigation? And the last question is death the appropriate penalty? So even if you vote yes, 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 the last question is never required to be yes, even if all the other boxes are checked. Does that make sense?
Yes, ma'am.
If one juror says that life should be the verdict, then life will be the verdict. Comfortable with that?
Yes.
Mitigation can be
Even if I'm that one juror.
Yep. And that's sometimes this is hard. That's why we have this conversation. Because sometimes you're already ahead of me envisioning yourself in the deliberation room, right? And that people have differences of opinion, and sometimes people are strongly opinionated about this. Make sense? And that in order for a just verdict to be returned in this courtroom, all 12 jurors' individual moral assessments about whether Mr. Loyd lives or dies have to be heard in this courtroom. Make sense?
Yes.
And so sometimes it's hard, but that's what the law requires, and it's your duty, your right, and your responsibility, and you can do that, yes?
Yes.
I got a little,
I didn't mean to say like she repeated that. My wife's a school teacher, so I know that the number of times you hear things is directly proportional to how important it is.
Yes, you get exactly where I'm going. We understand each other. So mitigation, I got a little bit off
That's
topic.
true in the military too. That's true in the military too.
Repetition?
The number of times you hear things is directly proportional to how important it is.
I suspect you repeated things a lot when you had control over a nuclear reactor?
Yes.
Okay. Mitigation can be absolutely anything. It does not have to be unanimous, and it can be unique to each individual juror. And as we discussed, it can be, at first blush, seemingly small. It could include, a smile observed between the defendant and a family member. So for that juror says, I saw that, I assign the weight of life to that, and I'm not giving a death sentence in this case. Make sense?
Yes.
If you are in the back and you have reached an individual moral assessment, and that is the verdict should be for life, and it's not being respected, you can say, hey, listen, we're done here. I've reached a verdict. Deputy, please get the judge. We can go home. With me? May I have just a moment, Your Honor?
Yes, ma'am. Either side need to approach?
No, Your Honor.
All right, sir. We're going to send you through to the next round of questioning. And so several things are now going to happen. Number one, if you'll hand your badge to the deputy, you can put your regular mask on and you don't have to wear that other one right now. We're going to make you a purple dot. Like I told you, I use the colors to call groups of jurors back in because there's just too many of you to call numbers. So you're now purple.
Is it because you weren't able to hear me?
The mask? The mask causes some problems with sound in this courtroom, so we just have people pull them down sometimes. You do talk very fast.
Back on.
So-
Yes, ma'am. I'm sorry.
So anyway, you're going to be returning for one final round of questioning. That day, we will be picking the jury. So we're giving you a package. It includes several things. Number one, it includes a slip of paper that gives you a phone number to call starting tomorrow at 5. You're coming back sometime next week. It's not going to be this week. It'll be next week. So you're listening for the purple group or the purple dots return on this date at this time. That will be jury selection. You'll need to have packed a suitcase because if you're picked for the jury, you're being sequestered that day. Just leave it in your car. We'll make arrangements for you to get it if you need it. If not, obviously, you just go home with it. There's also a letter in there for your employer telling them you're coming back again. And lastly, there's a jury sequestration packet. It explains more about sequestration, the rules, what you should bring with you to coming to sequestration, tries to answer questions you may have. Do you have any questions? 2 to 3 weeks. But we suggest you pack about a week or so because there is laundry there. Okay? So whatever you think you need to survive for 2 to 3 weeks if you do not want to do laundry. All right?
Yes.
Okay. Thank you, sir. Have a good afternoon.
Put this back on.
You can keep that lovely mask. It's our gift. You're welcome.